Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. Today, I'll be talking about something in CPC, about res judicata. What is res judicata? What's the meaning of res judicata? What is the doctrine of res judicata? What is the principle of res judicata? Yeah, so let's start with what's the meaning of res judicata. Res means subject matter and judicata means adjudicated or adjudged or decided, and together it means a matter that is decided or a matter adjudged. In simpler words, the things has been judged by courts. As I told you in my last video, the issue between a court has already been decided by another court and between the same parties. Hence, the court will dismiss the case as it has been decided by another court. Res judicata applies to both civil and criminal legal cases. No suit which has been directly or indirectly tried in a former suit can be tried again. If I give you an example of res judicata, suppose there's a person A who sued B as he didn't pay his rent. Now B pleaded for the lessening of the rent on the ground of as the area of the land was less than the mentioned in the lease, and the court found that the area was greater than shown in the lease. Actually, the area was excess, and the principle of res judicata will not be appealed. Now, what is the principle of res judicata? Let me explain. The principle of res judicata seeks to pronounce the fair administration of justice and honestly to prevent the law from abuse. Honestly, the principle of res judicata applies when litigant attempts to file a subsequent lawsuit on the same matter after having received a judgment in previous case involving the same parties. In many jurisdictions, this applies on only to specific laws and specific claims made in the first case, but also to claims that could have been made during the same case. Now, the prerequisites of the res judicata includes judicial decision by proficient court or a tribunal, a final and binding, and any decision made on the merits, a fair hearing, that is a must, and earlier decision, right or wrong, is not relevant. Now, what is the nature and scope of res judicata? Res judicata includes two concepts of claims preclusion and issue preclusion. Issue preclusion is also known as collateral estoppel. Parties cannot sue each other again after the final judgment on the basis of merits he received in the civil litigation. For example, if a plaintiff wins or loses a case against the defendant in a case, say A, he cannot probably sue the defendant again in case B based on the same facts and same events. Not even in a different court with the same facts and events. Whereas the issue preclusion, it prohibits the relegation of issues and issues of law that have already been determined by the judge as a part of an earlier case. The scope has been decided in the case of the Ghulam Abbas versus State of Uttar Pradesh. In this case, the state incorporated the rules as evidence as a plea of an issue already tried in an earlier case. The judgment of this case was difficult as the judges should apply res judicata. It was decided that res judicata is not exhaustive, and even if the matter is not directly covered under the provisions of this section, it will be considered as a case of res judicata on general principles. Now, what is doctrine of res judicata? The double jeopardy provision in the Fifth Amendment of the Constitution protects from being put on a second trial after the case has been judged. So the doctrine of res judicata addresses this issue, and it bars any party to retry a judgment once it has been decided. Now, the section 11 of Civil Procedure Code incorporates the doctrine of res judicata, also known as rule of conclusiveness of judgment. The doctrine of res judicata was explained in the case Satyadhyan versus Satyanand Ghosal versus Durden Debi. In the judgment of the court was delivered by a magistrate. In this, an appeal was made by landlords who attained a decree of ejectment against the tenants who were Mr. Debi and her minor son. However, they have not been yet able to get possession in execution soon after the decree was made. An application was made by the tenant under the section 28 of Calcutta Thika Tenant Act and alleged that they were Thika tenants. This application was resisted by the landlord, saying that they were not the Thika tenants within the meaning of Act. Now, I must explain res judicata and estoppel. Estoppel means the principle which prevents a person from asserting something that is contrary to what is implied by previous actions. It deals in section 115 to 117 of the Indian Evidence Act. The rule of constructive res judicata is the rule of estoppel. In some areas, the doctrine of res judicata differs from the doctrine of estoppel. Now, estoppel flows from the act of the parties, whereas res judicata is the result of the declaration of the court. Estoppel proceeds upon the doctrine of equity, and a person has induced another to alter his position to his disadvantages, cannot turn around and take advantage of such alteration. In other words, res judicata bars multiplicity of suits, and estoppel provides the multiplicity of representation of cases. That is it for today's video. If you like this video, please subscribe and share. Thank you.